Waslama, we are live now.
Okay, so we will wait for people to join in. We'll wait for another 6 minutes. It's yet 1 minute to go. So if you want, you can like stop the YouTube live right now and do it, start it after 5 minutes, if it can happen.
Let me know, Vatsala, when to start, yeah?
Yes, sure, please. Good evening, everyone. Thank you for joining us. Uh, I think we should just wait for 2 more minutes for others to join in and we'll start the session. Thank you for your patience. Okay, so greetings to everyone. Many thanks for joining us today for this another interactive webinar. We are live from the YouTube handle of the Startup Incubation and Innovation Center IIT Company. I am Vatsala Khare, lead of mentorship program at the incubator. This session today we have planned on legal advices is curated specially for the startups, and this is specially done on the demand of the startups. We will be covering the topics that have been listed by the startups themselves. So today we have with us Ms. Prachi Jain to deliver the session. Ms. Prachi is associated with Innovate Official, where she serves as Chief Strategy Officer. She is a chartered accountant ranker and a company secretary and holds a degree in law. Her professional journey includes participation in the Goldman Sachs 10,000 Women Program at IIM Bangalore and being a recipient of the GLI Fellowship in Asia. Ms. Prachi has been recognized as an iconic women director in 2023 and was listed among the top 100 women in finance in India in the year 2020. Additionally, she is a mentor, she is an investor, and has a strong focus on the ESG, that is the environmental, social, and governance investing. Ms. Jain is an esteemed mentor at our incubation center also. She's been associated with us for past 2 years officially. I will sincerely request all the startups to please participate in the session, ask more questions so that we can help you better. Please post your questions in the Q&A box, and anyone who wishes to speak, please raise your hands and we'll try to unmute you and listen to what you have, what is your question. So Prachi, now the session is yours.
Thank you so much, Vatsala, and thanks for the kind introduction. It meant a lot. So, as Vatsala said, we will be making this session to be more interactive. So we decided that we will quickly kind of explain those terms which Vatsala has note of in first 20 to 30 minutes and keep the balance for answering all your questions which you have. So Vatsala, I'm sharing my screen now. Is it visible to all of you?
Yeah,
Can
it's
you all
visible,
see
ma'am.
that?
Yes, we can see that. Prachi,
Oh.
please put it in a presentation mode.
Okay, fine. So hi everyone, this is CA Prachi Jain. I am Chartered Accountant, Company Secretary, and I also hold a law degree. I have passion to understanding various laws, and because of which, when I was part of the private equity and venture capital fund, I was part of the entire life cycle of the fund where I was not only involved at the time of raising funds, doing due diligence on the companies, which includes the financial due diligence as well as the valuation and making business plan, but also participating in what we call as a negotiations and legal documentation, primarily including your share purchase agreement, share subscription agreement, and other agreements, understanding the IPRs for our companies, and also that's where I think that interest aroused. And all these topics which I will be sharing with you are very close to my heart, and they are very important also. And a lot of times we do not understand the nuances pertaining to that, because we always felt that we are a non-lawyer, and therefore we think that whatever is written we should execute it, because सब लोग बोलते हैं तो ऐसा ही होता है agreements, right? So you just have to execute it. But this session tries to help you to ensure that you understand these clauses better and only execute these clauses when you have understood every bit of it, because the agreements are only being shown to you when there is a fight which is happening, right? Other than that, the agreements will never get opened up in the life cycle of whatever you're doing. So it is important that you know what you are executing or what you are doing is right, and you're wholly aware about it. So here we start our legal session. So firstly, I think these are various questions which come to your mind. Can you see the next slide? Can you please let me know?
Yes, we can. Prachi, please put this on a presentation mode. On the right hand side, you'll find the.
I know, but is it visible to you now, everyone?
Yes, yes, now it's visible.
Okay, fine. So yeah, so these are various questions which Vatsala it's kind of bothering all the startups, and I'll read out that for you. And I think you'd also ponder on this slide. I think everyone have these common question is what are ESOPs? When is the vesting period? How will I protect my product? Is my product IPable? What is the confidentiality clause? How to hire employees and manage them as startups? Can I share details with freelancer employees? How to protect my IP? What if employee steals my idea and IP since he or she is working on it? What are trademarks? What really I need to do to ensure that my product, my patent, my trademark, my IP is being protected? So I think this is what we will be seeing through the entire presentation. And let's start with understanding what are intellectual property, right? Which I think is very important for you to take the conscious call and ensure that the documents which you are kind of executing or applying for is correct. So this is the broad types of IP are prevalent in India. The copyright is primarily for your literary, dramatic, musical, and artwork, which I think may not be relevant for you. What may be relevant for you is the computer program, because you are all tech startups, and the tenure when you apply for a patent would be around 60 years. In addition to the life of the author, which is like whatever your life plus 60 years, the protection is being provided by the Intellectual Property Rights Act. I mean, so there are various acts. So copyright will have a Copyright Act, trademark will have a Trademark Act, patent will have a Patent Act. So the different acts which governs these particular IPRs. Then you have a trademark. Trademark is primarily means your logo or any color, symbol, shape which represents a good or a service. So Parle-G has its own trademark and its logo. So someone is trying to copying or mimic a product which looks very similar to Parle-G, right? Then Parle-G could actually file an infringement case against that particular organization, stating that they have tried to copy us and try to mimic us, thereby ensuring that in the minds of consumer the products are same. So, and you can do trademark for 10 years. Patent. Now, what is a patent? Patent is something which has to be invention. I think a lot of you will fall under this category of patent. Whatever I've seen while I was listening to your pitches or evaluating you. So it has to be a new invention. Patent can be for a product or patent can be for a process. So it primarily tries to protect the product from selling, making, or reporting without the prior use of the owner. So it's my IP. I'm the owner of the product, and the process patent again helps you in obtaining the patent for the process of the product, which if there is an invention in that. Again, this is IPable for the tenure of 20 years from the date of filing the application. So there may be a possibility you may file an application today, but you are granted IP after 5 years. Just take for example, because it takes a little longer time in India after 3 years. So your 20 years will start from today and not after 3 years when you have been granted. Design again is very relevant for you because you are working with a lot of these designs and patterns, configurations, and different stuffs whereby you have to ensure that you are filing the application for that. And when it is designed, you have to ensure that it has to be novel and an original innovation. It cannot be something which is already available in the public domain in India or outside India. And it has to distinguish itself from the other design. Again, the time period for it is 10 years and you can renew it further. Geographical indications, again, GIs, which we called as examples being Darjeeling tea, basmati rice, or something which is specific to a particular location where they're grown, or the weather conditions and all. So this becomes very important, specifically for a country like India where we have basmati rice, which again, unfortunately, we do not have the GI for because we didn't realize that we could actually do that. So it's important that country which has been claiming of basmati rice since ages do not even have the GI for that, because some other countries applied and obtained patent internationally for that. The semiconductor integrated circuits layout, again, products which have a circuitry elements or transistors, and they're inseparable and they form a semiconductor materials. Again, you have to get them IP. You have to apply under this particular act and you can get an IP for 10 years. Now, another new form is the Biodiversity Act, which has come in, and also the protection of plants and varieties, which provides protection to plant varieties in order to encourage the growth and development of more plant varieties. So companies which are in something like using nanotechnologies or working in the biodiversity space, or a seed company or a seed industry, right, where there's a lot of technological innovations happening in that. Those can also be applied for an IPR protection. And for trees and vines, it is 9 years the tenure, and for crops, it is 6 years. And of course, you can renew this. So this is a rough idea as to where you can identify yourself, where you are falling, because it's not every time patent, right? It can be a trademark, it can be patent, it can be design, it can be semiconductor integrated circuits, or it could be a protection of plants and varieties. It could be either of the things for you all, based upon what you are developing. Now, what is important is that we have realized that there's a lot of common issues which have with IPR. So a lot of times, specifically startups that do not have the IPR mindset. And a lot of times the IPR is in the name of a founder or a co-founder. Like, I'm a co-founder of this company. If I own an IP and I have another co-founder, then there's a possibility that if I move out, I also take along IP with me. And as an investor, I am not very happy if it is in the name of an individual. So I have always been telling people that ensure that the IP is always in the name of the company rather than an individual. Even if it, so last time also I was speaking with Vatsala and there was this company which has come up. The IP was in the name of the co-founder, and I've specifically told them ensure that the assignment of that IP immediately happens in the name of the company, else it becomes very difficult because it will be not good in the eyes of investors. They may not really like it. A lot of times we have imperfect titles or ownership of IP due to failure to obtain proper IP assignments, which I just spoke about from employees, consultants. So a lot of times we are working with a team. I am the founder, co-founder, but there's a team who is working with me. They are having access to all the details. And sometimes there is a possibility that we may take an IP in the name of an employee. And again, if the employee is leaving and there is no assignment, or the employment contract itself doesn't have these clauses, then the employee can claim that the IP belongs to me and not to you as a company. So we have to be very, very mindful about all these things. A lot of times, as I say, I've spoken about the time frames, right? 60 years, 10 years, 5 years, 9 years, 6 years. These are the tenures for which I can apply for my IP, like the period. After which, in few, there is a clause for renewable. So a lot of times we forget to renew the IPs, and then that's where when we kind of lose it. So we have to ensure that, because we are still in the development phase, that changes which is happening, that we have to have timelines or maybe calendars to ensure that we renew our IPs when it is getting due, and ensure that you have the complete record. In lack of or incomplete record of IP amount is the gross mistake which we are doing, because if this is the basis of my entire product or service which I'm rendering, and this is the basis for my company to grow, then I have to ensure that my IPs are protected in some way or the other, and I can't be lenient about it. So these are IPR common issues. Now, getting on to employee onboarding, which again, as a startup, you always find issues with. So I understand that
Prachi,
employees and onboarding of employees can be, specifically in a startup, when you're working in a lean team and you do not have a separate HR team, maybe chaotic, messy, complex, because if you like them, you really hire them. But the employee is clueless as to whom to report to, whom to ask for a laptop, whom to whom to take assignments from, because you as a founder are relatively busy, right? So it and the issue being, you don't have the money, आपके पास पैसे नहीं है to have a full-fledged HR person to ensure to take care of everything, the payrolls and everything. And again, as a founder, you have 5 other things to do, and you do not want to use your mind into this. Of course, you'll be very much part of the hiring, because as a founder, you know which kind of team you want to build, but maybe you do not want to get involved in the nuances of, like, oh my God, iska payroll kab hai, payment kab hai, isko kaun report karne wala. So I think these are various issues which comes up, and the solution is simple. Ensure that you have at least the SOP. As a founder, I think you have to hustle, and you also have to wear separate hats, because every time when it's about frugality and saving some money, right? You will always opt for saving that amount of money. And if you do that, you have to put that hat on your head and say that, boss, I have to do this. But also ensure that when you're doing this, you have team members who understand this, at least one or two. So you should have templates for appointment letters and employment agreement. These are very standard. Ensure that you have good confidentiality clauses, as I discussed in the IPR section, जहाँ पे हमने ये बोला है आपको कि बहुत बार कुछ चीजें होती हैं जो एम्प्लॉयज कर रहे होते हैं, कुछ बार कुछ लॉट ऑफ टाइम्स हम एम्प्लॉय को रखते ही इसके लिए कि उनके पास एक आईपी प्रोडक्ट होता है या उनके पास कुछ डिजाइन होता है विच वी थिंक कैन बी आईपीएबल. सो इन सब चीजों को ध्यान में रख के जब हम एक एम्प्लॉय व्हेन वी काइंड ऑफ hire an employee, right, we need to include those clauses pertaining to confidentiality, non-disclosures. Further, if you want that IP to be assignment of IP at the time when the employee is moving out or employee is okay giving that assignment, whatever the agreement between the two parties. So we have to be very, very clear. Plus, Google Forms are like a life savior. So we should have a template Google Form for entrance of employee into the company. So as soon as an employee comes, there should be a Google Form which and these are all things which I am telling you so that you can save on to money. Otherwise, there are a lot of I can say how you have a virtual CFO, there is a concept of virtual HR also. So that HR will kind of provide you policy so that you can take care of an employee. But I'm talking about when you are at the stage where you are, where you do not want to spend any amount of money, you have to work a little harder. You can have a Google form where you can have all the details pertaining to an employee, like name, their address, Aadhaar, PAN card, where they are staying, how much salary they are drawing, their father's name, their emergency contract, their mother's name. So we'll have that entire thing in the database which we have. And that will, all, of course, including their bank account numbers. And then we can give this to someone or your accounts team who is kind of processing the payment. So then you don't have multiple things. So as soon as an employee comes in, you have to give this form so that everything is there in the Google sheet. Right. And this is an easier way. I'm not telling you that you don't have to hire HR. Of course, as you grow, you have to. But in the initial phase, this is what you got to do so that all the information are there at one place. Again, it becomes very difficult, as I was talking about, wo kahan baithega, kya karega, who is the reporting authority, whom he has to go and seek for work, is he directly working with you? You have to define them very clearly. You have to give those things, and you have to also ensure hiring is again a very tedious exercise. A lot of times you don't get the right hires. So you have to ensure that you're spending little time on all these things so that you set the system, set the SOP so that you do not have to worry about it later. Also, you could, as I say, that once you grow a little bigger in your size, you could get not a dedicated HR, but you could have something what we call as a virtual HR team, wherein the services of that HR, so there are companies which provide those services to you, and they will take care of this entire payroll processing, employment agreement, appointment letters, who is the reporting authority, so you maintain all those things, and you know what you need to do. Now, something which is very important and which Vatsala spoke about are the non-disclosure agreements. What are non-disclosure agreements? These are primarily agreements between two parties. One is the receiving party and one is the so there are two parties. One is the disclosing party who is giving the agreement. Party who is disclosing the information, and the other is the receiving party who is receiving the information, right? So we need to understand that for any NDA to happen, there has to be these two parties. Okay. Now, a lot of people ask me what is the enforceability of NDAs or confidentiality clauses in India. Okay. Of course, there is a debate around it, but if it is drafted well, it is the NDAs and confidentiality clauses are enforceable in India, provided it is not hampering the rights bestowed upon an individual under the Constitution of India, which is the right to carry out its own profession or a business for its livelihood. I think until the time you are maintaining that, the non-disclosure agreements are enforceable. Plus, it is not mandatory for you to register the NDA under the Registration Act. But a lot of times when you register any agreement, okay, in India, I think not a lot of people are doing registrations of their agreement. But if you do that, in court of law, it becomes an admissible evidence. Otherwise, also it is, but a registered agreement is like a pure form of evidence in court of law when there is a ambiguity or fight between the party. Now, coming to the fact, what are the types of non-disclosure agreements? So there could be three types of non-disclosure agreement. One being unilateral confidential agreement. Second is bilateral confidential agreement. And the third being the multilateral confidential agreement. So in the unilateral confidential agreement is primarily, we can take an example of where you have hired an employee. That employee is working on some software or given some assignment or working for a client. And you are giving entire detail to that person. Okay. So that person is not giving you any details, but you are giving all the details to that person. It becomes unilateral agreement, and that receiving party, like the person, that employee who has received the information, is under an obligation not to divulge that information to any third party. If he or she does that, then you can always pull them in court of law or seek compensation or indemnity if there is any loss or damage being done to you by that information being divulged to public at large. Second is bilateral confidential agreement, when both receiving party and disclosing party are giving information to each other. So this typically happens in a scenario when you have announced a mergers and acquisition, or where two companies are forming a JV coming together. In that scenario, we were discussing like a couple of days back, again, IIT Kanpur company. They have a technology transfer agreement with a Japanese company, and they have come together. So there are few things which they have told them, and there are few things which the Indian company has informed these people, so that they come out with a better product. So there is a transfer of details between both the parties, and this is called as a bilateral confidentiality agreement. Third is the multilateral confidentiality agreement, wherein one party provide a detail. So there is one disclosing party and there are multiple receiving party. A classic example being if you plan to have a franchisee, right, of Goli Vada Pav or a Burger King, any of these, right? When you do that, in that scenario, you will tell that franchisee owners what the recipe are, so that they are similar to what the HO is providing. So this is exactly where you will have one disclosing party and multiple receiving party. Again, all the receivers have to maintain confidentiality. If they're in breach of that particular confidential clause, which NDA stands for, then as I say that you can claim you can claim damages, you can claim indemnities from these people, and of course these are also part of the NDA agreements which you will be entering into with your employee. Again, coming to confidentiality clauses, we have spoken about it. What is confidential information? It has to be information which is not publicly available. First of all, it is not known to you from the company, but from the other part. So it is known to you from the company and not from the outside source. So something which you get to it from the outside source is definitely not a confidential information to you. And this is an information which can be legally protected. So this information is classified, privileged, and very, very specific to that particular company. And confidential clauses. So NDA is just one agreement, non-disclosure agreement. So any information which I'm disclosing to you, you should not be giving it. But confidentiality clause is a clause which can be part of so many agreements across, because always there's some kind of confidentiality happening between the two parties. And it may not be always the NDA agreement which you are executing. So even an employment agreement, which is not an NDA, non-disclosure agreement, may have confidential clauses. The idea is to protect yourself from any information leaking out of the organization. So confidentiality can be part of the following agreements, which I've just listed out. This is not a list. There can be exhaustive list also, but this is few examples which I gave as an employment agreement. Non-disclosure agreement, again, also have the confidentiality clause, the reseller agreement, license agreement, technology transfer agreements, mergers and acquisition. And when you're talking to potential investors, when you've executed the term sheet, you are under the confidentiality clause that you're not going to reveal what are the terms of this term sheet to any other investor, right? So that you can just kind of sell those term sheets. So this is not allowed when you do that. A lot of people do that, but it's not ethical. Now, what is confidential information? I think this is very important for you all to understand that it means an information which is relating to business, finance, dealings, transaction, affairs of the company. So it has to be related to the company. It need not be any. So as I said in the earlier slide, we have seen that it has to be very, very specific. It has to be privileged and classified information. Secondly, as we just spoke about the IPR, so all your intellectual property rights fall under the confidentiality, because these are either trade secrets or there are programs, there's business opportunity, your research, development project, technical data, all these things whatsoever part of the company and which is benefiting the company. This needs to be protected and therefore forms part of the confidential information or being defined under confidential information. When I say there are certain analysis or views taken by the company in respect of business, finance, dealings, and affairs of the company, and any other information in respect of its company is bound by obligation of confidentiality. So, assuming if it's a law firm and there is a privacy with respect to the details which the client is being provided to the lawyer, then the company is bound not to reveal those details publicly outside. So, this falls under the confidentiality obligations of that particular profession which you are in. So, this is all about the NDA, the confidentiality clause. Now comes very interesting topic which you all what is ESOP? It's an employee stock option plan. What it typically means is, so what's the purpose? First, let's understand the purpose of ESOP. The ESOPs are primarily given to employees. It's an employee benefit plan that gives employees the ownership of the company. So, actually acquire a particular stake in the company, and shares are purchased by employee at a price below the market price. So, assuming that if the market price is rupees 100, the company gives you an option to buy the ESOP from the company at a discounted rate of, let's say, 50. So there's a 50% discount to that. And employee, all you need to understand is an option and it is not an obligation. So when I say an option, you have an option to convert it into the stock, but it's not obligated for you to convert it into a stock. So if you wish to, you pay that price and convert. If you don't, it's fine. And what is the purpose? Why such hustle around this particular word? And why a lot of startups prefer giving a combination of an ESOP as well as salary to an employee. So the idea is that they will be more committed. A person who is okay taking an ESOP and taking a haircut in the salary, okay, is committed to the cause of what you are doing. It's also a good way of retaining it because you want them to be part of the success story of the business. It also motivates them because when you say I own ESOP, you're owning a part of the company, right? So if this company will become $1 billion company tomorrow, you're already a millionaire by that time, right? It gives you ownership and it is time bound, like within 3 months or what? Sorry, not 3 months. Within whatever the vesting period is, you have to apply, choose that option to conversion. Now, coming to very important terms, which 3 terms which are very important when we're talking about ESOP is the vesting period, the exercise period, and the exercise price. We have spoken about the exercise price right now, that exercise price is typically lower than the price prevailing in the market or as per the valuation report. So if your share price is 100 rupees, you will offer, because they're your employees, you may offer them a discounted price of, let's say, 80, 30, 40, 20, whatever you feel like giving. What is a vesting period? Vesting period primarily means that a period, vesting period. So you have given 3 years time to your employee. So you have given employee the ESOP today, okay? And then you have told them that you have a right to exercise them after 3 years. So 3 years is your vesting period, which technically means that if you're giving your employees, so you've granted them ESOP. So today I grant them an ESOP that you are the owner of this particular ESOP, which is like 2% or 1% of the entire stake of the company. But it will get vested only when you complete 3 years in the company. Okay. So my vesting period gets over after 3 years. And after 3 years, I have a right. As I say that it's an option, not an obligation. I have a right to convert that option into share. If I opt out of it, then I'm telling that I don't have any ESOPs, right? And what is the exercise period? Exercise period is primarily the time period which starts after the completion of vesting period, within which an employee can exercise his or her right to apply for shares against the vested option, which technically means vesting period 3 साल के बाद खत्म हो गया, उसके बाद मैं बोलूं कि आपके पास 2 महीने हैं, within which you have to exercise the option कि आपको भाई खरीदना है कि नहीं लेना है हमसे शेयर. Because if you have to buy, then you have to give me the price. Let's say you want to buy 100 shares. Give me a discounted price of 50 rupees, 100 into 50, 5,000 rupees, which is what you want to, you have to give me to acquire those shares. So this is primarily understanding the ESOP in the best possible, quickest manner. Lot of times people get hassled of it कि भाई इसका tax liability क्या है और ये structure कैसे होता है. So tax liability, so there are two effects, like there are dual effects on, or I will say the taxability of ESOPs is bifurcated into two parts. First is when the employee exercises their rights and purchases company stock after the vesting period. So 3 साल हो गए, 2 महीने और एक्सरसाइज पीरियड जो हमारा 2 महीने था उसमें हमने डिसाइड कर लिया कि हमको ये लेना है. तो वो जब हम एक्सरसाइज कर लेते हैं और हमको डिसाइड कर लेते हैं कि ये हमको लेना है, it is taxable as perquisites in the hands of employees. I'm sure everybody would have worked in corporate world sometime or the other before starting your own startup. Perquisite is part of the salary of an employee. तो वो जो effect होता है, I mean वो जो difference होता है is regarded as perquisites in the hands of employees, which is your fair market value minus the exercise price of the share. आपका fair market value 100 rupees था, हमने exercise price उनको 50 rupees दिया, okay? या 40 rupees दिया, let's take 40 rupees, right? So FMB minus 40, 60 is the perquisites in the hands of employees on which they have to pay tax based on the slab rates which they are falling. This is for the employees. Plus, we provide a lot of flexibility to startups, and as per the regulations, the employees who work in a startup will not have to pay tax on the perquisite in the year in which they have exercised the option. So they are differing that. So they have to pay it in the year when the employees are selling the stock. Now the second effect or taxability comes when the employee sells the stock after exercising the option. So I've exercised the vesting happened in the 3rd year, option exercised in 3 years, 2 months. After that, if I continue to be an employee of the company and I want to sell shares in the 5th year of the company because company is now listed and I want to take a little pie of that, whatever I have kind of done for the company by selling a little bit of my shares. So what I will do is I will sell the share. When I will sell the shares, there will be capital gains tax on the share. And what will be that capital gains tax? It will be my selling price, which at price which I'm selling. So 100 rupees का जो मेरा share था, after 5th year, my selling price is 200. So selling price is 200 minus fair market value, which is the fair market value when I've exercised the option is 100. So my capital gains is 100 rupees on which I have to pay taxes again. The employees have to pay taxes again based on the slab rate which they are falling, whether they are under 10%, 20%, or 30% slab rate. So this is just a slide which I thought would be again relevant because we're talking about legal issue. What is the legal entity or status of the entity? So primarily, you may start with a sole proprietor, move to a partnership firm, or may get registered yourself as LLP or a private limited company. The unlisted public company and listed public company is not relevant for you right now because you are a startup. But based upon the stage where you are in, you may decide to form either LLP or private limited company. Typically, you don't get investment when you are a sole proprietor, when it's in when you yourself is owning the company and there's no other person, and when it's an unregistered partnership firm. So it's always better that you do LLP structure or a private limited company structure for you. Of course, this is all based upon the stage of business you are in. What is the ease of formation? What is the cost? Are you okay spending that kind of money? What is the compliance requirement? What is the liability which you are looking at? Ability to raise capital. So even if LLP is a good structure, there's a gray area which says that it's very difficult for an LLP to raise funds from foreign investors. So from domestic LPs, it is okay, but from foreign investor, it becomes difficult to raise funds in the limited liability partnership structure. So what you have to do is you have to create a private limited company or convert it into a private limited company. Transfer of ownership, how you want to do it, and perpetuity of business. Of course, sole proprietor is not perpetual. Limited liability partnership again is not perpetual in the sense that if all partners die, then the liability LLP will get closed down. So there need to be at least 2 minimum partners in the business. However, private limited company is irrespective of the directors, whether they are alive or dying, because then they will hire more. The life of private companies is perpetual. And unless you wind it down or liquidate it, and shareholders may come, shareholders may go, but the life of the company continues forever. It's like that. So based upon all these criteria, you decide onto this. Here I pause. Now I'm happy taking any questions which you have. I tried explaining what Vatsala told me that was relevant. in terms of the question which she has received from you. However, if there's something which is unanswered and if you have direct questions very specific to you, happy to answer those for you. Thank you so much.
So thank you, Prachi, for covering all the topics that we had asked you. There are three questions that I currently see in the chat box. It's being asked by an incubator, Kanishk Viswas. Uh, how can we confirm, check the novelty or claims before finding a technical patent? Google patent search is enough, or please suggest. Sometimes Chinese patents are written in Chinese, so how to get into the details?
So you need a lawyer who will do that on your behalf. Primarily, what you call it as so when when you are applying for your patent, right? Even when you're doing Google search, right? You have to ensure that you're doing it through a legal, and it's always good. I jokingly tell a lot of my people that as a startup, you need two people as friends, a CA and a lawyer, because they will do work for you on an honorary basis because they are your friends. They really want you to grow and will not charge you. So it will be not deep on your pockets. I do understand that for Chinese patent is difficult, and then they may kind of. So I remember a very classic example since you spoke about this Chinese patent. So we have a trademark company called Alibaba, which is into the QSR. I mean, they were into the food restaurant business. But can you guys hear me? Hello, Vatsala? Hello, am I
It's
audible?
audible, ma'am.
Okay, fine, because I can't see Vatsala. Sorry. So I remember they have received a notice from the Alibaba, the e-commerce company, that they have used their trademark. However, they were in two different industries, and it's very difficult to figure out that an e-com company would kind of make that application. But yes, Chinese are always on the lookout. And it was only a trademark with a very different logo and all, but still they said that the name will confuse. However, they're in two different segments. So you have to be very, very mindful. And so I think this is what your lawyer may help you figuring it out whether your claim is novel or not. But I think for the patent, what they also do is, if I remember correctly, they will, once you file the patent, the authority itself will publish it. And they will publish it for certain time period so that someone will come and claim that this is mine. If they are not claiming within that stipulated period, which is being defined that it is mine, then that the patent is being given to you. Once it becomes your patent, then that person who has not patented, and when that process is happening, cannot claim that this is my patent. So even patent laws are kind of getting better in India over a period of time. I would say over past 10 to 15, 10 years, they are becoming like pretty vigilant in terms of figuring it out because they want to make Indian patent laws at par with international laws. So that's answer for Kanika Biswas. Kanika also has another answer. As you have said, patent need 5 years for getting granted. So I can disclose my patent before my patent is granted. No. I didn't say 5 years. I just said that it's an example. So you may get patent in 2 years also. It's a process. You have to apply for a patent, then step one, stage two, stage three, depending upon how complex is your patent. Secondly, when you apply for it, there is, as I said, a cooling period where people can come and claim that this is my patent or this is my invention, right? Even those periods have to be considered, but I didn't say that it is 5 years. I just gave you an example because I was trying to tell you that the tenure for calculating the patent applies specifically for a patent applies from the date you're applying for the patent and not when the patent is granted. So I just said that maybe if you're granted patent after 5th year, then you can't say that no, my time period for 20 years starts from the 5th year. No, it will start from T, which is the first day of the application of the patent. I think Kanika has a lot of questions. Can we publish data in scientific journals before my patent is granted? Oh, that's very, can we publish data, experimental results in scientific journals before? Of course, I think you can do that. What's stopping you? Because you're not revealing your patent or your invention. You're only talking about it. So ensure when you are even publishing it, you have already applied, at least applied for the patent. मतलब ऐसा मत करिए कि आप सब publish कर दीजिए और उसके बाद patent को apply करो. Patent apply कर लीजिए. It should be in the process with the government authorities. And then you can provide your results and ensure that you're not revealing all the data. because it's ultimately a journal, right? And 1,000 people may be reading it. So उसमें सब details देने का जरूरत नहीं है, but maybe you could talk about the findings. So maybe you could say, just take for example, like I have worked for a company where they were using a very using a process whereby when they were processing the cotton seed oil, okay, the de-oiled cake which used to come out of it has the ability to increase the, and de-oiled cakes are primarily eaten as fodder by milch cattle, right? Cow, buffalo, and goats. So the outcome, so you can write the outcome. The outcome was that there was increase in the capacity of milk yielding capacity of these milch cattle by 20%. So that's the big breakthrough which you can write, but they will not write that this is my process because they've already applied a patent for it. So don't get into the process about it, but you should write that and ensure that आप जितना हल्ला थोड़ा कम करो उतना better है. Getting into all these journals and all because it's I don't know. A lot of times you will come and say this is my patent. I've applied for it long back, and then you don't want to get into that litigation stage in the very first or second year, right? So keep your head low, ensure that you've granted patent, and then you go all out. You can talk about it on various forums, but putting it in the general, I don't know how much details you should be giving in the details. Maybe Vatsala will tell you because they have a lot of journals how people are kind of publishing their details and all. I think that's what is important.
Yes, we will keep a separate session for this IP. We have an expert with us in-house itself.
Oh,
Mr.
wow,
Ravi
that's great.
Pandey, I think Ravi answered one of the questions. Deepak, can you promote Ravi to the panelist, please?
Okay, Siyama.
Till the time we are having Ravi as the panelist, there is another question. If there is any case where intellectual property are violated by some big and strong market player, whether trademark or patent can be range of cost of legality to deal with.
Sorry, I didn't hear it, Vatsala. Where it is
Yeah.
written, I can read it
It's
for
in
myself.
the chat box,
Okay. I can see Ravi's answer, but I can't see any other.
just
Okay,
above that.
Okay. It is by Pranay, 1 minute. It is
Pranav.
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 Is if there is, hi Ravi. Yeah. Is there any case where intellectual property are violated by some big and strong market player, whether trademark or patent? What can be range of cost of legality to deal with? So when you say violated by some big and strong market player, you meant to say, I just clarify that question, that it is your patent, your trademark, your copyright, and big company, like any company, which I'm not naming, any company have kind of infringed it, is what you're trying to tell? Or it's the other way around?
So, hi Prachi, she is asking about the charges over litigation hearings.
No, I understood it. So the point I'm trying to ask you is that if it is the other way around, so if someone has infringed your thing, okay, and what can be the range of cost of legality to deal with that? So see, range can go anywhere, right? It's not defined anywhere. So it's based on the damages which you have suffered at your end and how best your lawyer can put forth your case. So assuming if a big player has infringed upon your trademark, copyright, patent, whatever it that be, you have to file a case against that, right? And based upon the damages which you can prove that you have lost, let's say 20% market share, which amounts to 100 crore of revenue for me over the period of next 5 years. That's what you can charge. So you have to have very subjective and objective. First of all, you should understand what it is, and an objective approach of calculating every number ki boss aapko kitna damage hua hai. And that damage, liquidation damages, is what you can ask from that person. वो कितना देगा नहीं देगा, it's not the answer, but आपको कितना नुकसान हुआ है is what you have to ask from the other part. Ravi, I don't know if you want to add something to that, because this is what I've understood her question is.
Okay, I understood it from a different perspective. Maybe you were right. I could not get
Ravi,
it.
can you be a bit louder, because your voice is coming very muffled to me.
Just give me a moment. Am I audible now? Audible
Yeah.
enough?
Yes.
Okay. So I also understood it from that perspective only, that she may be asking for the litigation charges. So hi Prachi, I also happen to be an advocate by educational qualification. There was a question by Ms. Kanika over the novelty search reports, whether to generate those search reports before the patent application filing. So I wanted to answer that question.
Please go ahead.
Kanika, the novelty search report, or it is often known as prior art search or patent search reports as well. These reports are generated before the patent application is being filed. It is a simple process just to compare whether your current invention is novel or not. So how we do it, we basically draw an abstract. From those data abstract, we try to segregate what are the key features. And out of those key features, we try to find it out what are the key words out of that. And it is an extensive process which takes sometimes couple of days to 4 or 5 days. And we end up with comparable results that may be a patent, existing patent literature, or maybe a non-patent literature as well. But it is always advisable to have an extensive patent search report before filing a patent. I think I answered your query.
Thank you. Yeah, Pranav, we have put you in the panel session. You can please speak your question. I think if we've not been able to answer it properly.
Yeah, hi, am I audible?
Yes, Pranav.
Yes.
So yeah, you understood my perspective. If the patent is owned or any intellectual property is owned by me or company and it's being challenged or infringed, as ma'am said. So I think she covered the second question's answer, that there is no limit to that range. Only we have to understand it properly as to what is the cost of damage, or in details. I also just want one point to be covered. To conduct this type of exercise, I mean, as Ravi sir says, what can be the cost of legality? I mean, what can be the cost of all such activity? Maybe, yeah, that's my
So
point.
Pranav, I will say it's a very subjective question. So if you have a friend, he may
Okay.
charge nothing to you. If you have someone who believed in your cause, because it's the other way around, you are a very small company startup and some big company has infringed. I personally know lawyers who do this as a pro bono case. You're getting my point. They're very happy helping people like you. However, it depends upon, अगर आपको इतने बड़े आदमी से लड़ना है तो आपको लॉयर भी तो बड़ा ही रखना पड़ेगा ना, मतलब you have got my point that when you have to fight the biggies, you also have to ensure that the lawyers are able to at least withstand that kind of person जो सामने वाला आपके लेके आने वाला है, right? Because I don't know if you have ever seen the courtroom dramas or courtroom cases.
That's why.
Lot of times, even though your lawyer may have the best of the knowledge, but when it comes to countering each other in court of law in front of the judge,
Correct.
a lot of times they get very scared because there's a senior lawyer just standing because वो बोलेंगे मेरे mentor थे, मैं उनसे पढ़ा था, right? So who really need someone who really understand your case, want to fight for it, and as I say, it can go into lakh and it can go into zero, assuming someone thinks that this is the right case and it's a pro bono case which we should be taking. There are so many legal firms which take pro bono cases for so many people.
Okay,
And I don't know. I mean, personally, if you ask me if I truly believe मेरा जो product है और जो मैंने बनाया है, it is being infringed, and this is what my life is, I can go to any level to ensure that it is being protected. Having said that, and would have spent like 7, 10, 15, 20 lakhs, whatever that amount be. Having said that, we also have to understand that there has to be certain sanity, because there's also an opportunity cost. When you are fighting in court of law, you are leaving everything aside and just being concentrating on that, right? And it is not an easy task to do that, whether it is a civil law, it is an IP law, or it's a criminal law. The kind of amount which you kind of be investing, you have to balance and weigh the balance and figure out trade-off मेरा कहाँ पे बैठ रहा है.
Not on me, yes. Thank you, ma'am.
Yeah. Thank you, Pranav.
We have another question from Jatin. For ESOPs, how is a pool created? Is it fixed or can be changed over the years? And how much discount can be given to employees? Is there a possibility to buy back the shares from the employee by the employer itself?
Yeah, so can I read that question where it is? It's in Q&A because there are 3 questions. Okay, fine. I saw Jatin. So, so there are 2 ways in which the pool can be created, or ESOP. I will say not the pool being created, ESOPs being granted to an employee. One is directly being granted to an employee. So you directly grant an ESOP to the employee. The second is the company creates a trust. Okay. In the trust, the company, let's say, owns 10% ESOP pool. I'm just giving you an example, 10% of ESOP pool, right? And that ESOP pool, I will identify 15 employees in my organization whom I have to give that ESOP, right? So maybe I'll give to someone 2%, I'll give someone 0.5% of the stock of the company. So these are the two ways in which either you do it directly, like the company issue the ESOP directly to the employees, or they do it through the trust route. Both ways it is just to ensure that मैंने जो आपको perquisite वाला बताया, right? अगर वो directly आपको दे रही है तो आपके हाथ में perquisite हो जाता है. और बहुत बार एम्प्लॉइज बोलते हैं यार मैंने तो बेचा भी नहीं है, कुछ बेनिफिट नहीं है और मैं टैक्स दे दूं उसके ऊपर. And the tax rate may be around 20-25%. वो slab में तो आप बैठोगे 10 से 20% पे. So we do not want to do that. So a lot of time what the companies do is they create a trust. So that liability, because it's not an employee, doesn't come there. But capital gains tax के time पे वो सीधा आपका 300 minus 100 रुपया करता है, तो 200 पे आपको capital gains लगता है instead of 100 rupees in my earlier example which I gave you, right? तो trust के तरीके से होता है वो, मतलब you can do it. I mean the companies can do it. Second question is, there is the possibility to buy back the shares from the employee by the company. Yes, I think you can buy back, because once they are the shareholder, they are the shareholder of the company like any other shareholder of the company. तो जहां मैं किसी से भी बाय बैक कर सकती हूँ, मैं उनसे भी बाय बैक कर सकती हूँ as per the Companies Act. Okay, so there is nothing like कि ये ESOP उसको सिर्फ नाम दिया गया है. ESOP technically means a part of the share equity given to employees of the company जो मेहनत से काम कर रहे हैं. There is also concept of sweat equity जो कि फाउंडर या ओनर्स को दिया जाता है. बट नेचर तो सेम है. इक्विटी मतलब इक्विटी, अभी वो आप उसको ESOP बोलो, इक्विटी बोलो या स्वेट बोलो, इट जस्ट दैट यू गेट अ डिस्काउंट ऑन इट बिकॉज आप एम्प्लॉय हो कंपनी के, तो आपको बेनिफिट मिलना चाहिए. As far as third question is pertaining to how much discount being given to the employees, it's again subjective, depends upon company to company वो क्या ESOP scheme float कर रहे हैं. तो ESOP का as per the Companies Act and as per the regulations, rules जो laws Companies Act के अंदर there are rules. उसके अंदर you have to create an ESOP scheme. There's a particular format in which you have to do it. It's an agreement. And in that you will put the vesting period, the exercise period, the exercise price, the discounts to the scheme, discount to the fair market value of the company. तो वो सब उसमें रहते हैं. It can go from 20% to 30 to 50% also. I mean there is no limit कि नहीं मैं 2% ही दे पाऊंगा या 5% या 50%. It is based on the policies of the company. दूसरा कंपनी कितना प्रॉफिट बना रही है और कंपनी को वो पूल में जो दिख रहे हैं लोग उसमें क्या बेनिफिट दिख रहा है. थर्ड क्वेश्चन, कैन द पूल बी इंक्रीज? यस, पूल कैन बी इंक्रीज. बिकॉज अभी आप 15 जन हो, कल और 15 जन आ गए जिनको मुझे लगता है देना चाहिए, तो मैं थोड़ा आपका घटा के उनको देने वाली हूँ. आई विल जस्ट इंक्रीज द शेयर कैपिटल ऑफ द कंपनी एंड इंक्रीज द ESOP pool by that.
Sure. We have another question. We have granted a patent in India 6 years ago. My question is, what if another startup filed patent for a similar idea and we didn't notice and raised issue during the period when it was open during assessment? What exactly will happen after that?
So Ganesh, I think Ravi will be a better person to answer that question because I'm not someone who's dealing in the applying of the patents. But as far as I just understand it, that you have to, you should not be missing that, Ravi. I think because you have to tell while you're applying. So I think Ravi will be a better person to answer that question. But you have to ensure that you're reading those things because it's your patent ultimately. Ravi, please go ahead and answer this question.
So Gangesh, there is a foolproof process through which any patent application goes. One is the patentability that gets checked in the initial go. Section 3 clearly checks what are not inventions, and eventually any invention falling under that category would summarily be rejected. That is one. Now someone parallelly has filed another patent application after filing of a patent by you. So you need to understand the first one who files the patent gets the eventual grant of the patent subject to all the terms and conditions of the Patent Act 1970. That is number one. So you don't need to worry if someone has filed a patent application after you have filed. The only thing that matters is the number of specifications or the type of specifications that will be there. The specifications would be compared. So a general thumb rule is, we assume that if I filed a patent for a mobile application, another one cannot file a subsequent patent for a mobile. So that is not the case. if the specifications for a specific mobile phone are different to that of a previous patent application, then both would be
Will be granted.
compared, and if they are different, then both will be granted eventually.
Right.
In case
So-
if there are overlapping, then the number of specifications would be there. That would be strike down and removed and would be eventually asked by the examiner during the first examination report to strike down or to remove those number of claims. So that is a normal process. You file a patent, it gets published, it gets examined, you get an opportunity to respond to your first examination report. Upon FER response, if still the examiner is not convinced, you will still get an option to go for a direct hearing. Even for the hearing, if the examiner is not convinced, you still get the option to go for a written submission, post which likely if the invention, the patentability has been properly checked, the claims have been drafted properly, there are chances that it would be granted easily. In our case, we use the expedited mode of patent filing and publication. So it may have taken 6 years for you, but 95% of our patents are getting granted in less than 6-7 months of time. So that is a kind of accomplishment that we are enjoying. We hold a portfolio of around 1300 patents. We are filing around 200 patents a year. So any day, if you have any query, we sit in the old Sidvi building. Please be our guest. Welcome here and ask a number of queries.
So guys, you have Chalta Phirta Encyclopedia of applying a patent application. So these are the questions you should be asking to Ravi, because he's actually doing that on the ground, right? Wherein he's filing applications, he's ensuring that it is matched and whatever he spoke about. So thank you so much, Ravi, for that detailed explanation. Even I have learned that. And as I said, I'm not someone who is writing applications and patent application for it's sort of passion. I do all these things like more of understanding the IPRs, the Companies Act and all. But it's so interesting to listen. And I think next time I would be ready and with the kind of knowledge you have, I would also be ready with all the sections and all in place. At least Companies Act, I can tell you Companies Act, SEBI, FEMA, but not patent.
Okay, so we've come to the end of the session. Thank you so much, Prachi, for your expert advice on legal issues. And we have given a glimpse of what we have in-house, Mr. Ravi Pandey, an IPR expert. We will be having a session very soon for you guys on IP issues that you are having. So thank you, Ravi, please, for coming up and answering the questions promptly. Thank you,
Thank you
Prachi.
so much.
Thanks a lot for your time.
Thank you so much,
everyone, for
Vatsala. Thank you
joining.
so much, Ravi, for taking those questions. Thanks. Bye-bye. Take care. Let's be
Have
in
a good
touch.
day, everyone.
Bye-bye.
Bye-bye.